House Committee on Science and Technology. We'll be getting started here momentarily. Again, I'd like to welcome you to the House Committee on Science and Technology today. We've got a hearing this morning and a field trip this afternoon. This morning is going to be a presentation by the American Institute of Architects and some friends to discuss the issue of copyright and intellectual property for design documents. This afternoon, we're going to be having lunch and a tour of the Google Data Center in Douglasville. We've got a bus arranged for that, as many of you know, and some of us will be driving out there. So have a good day planned. Appreciate everybody coming to be with us. Just to kind of tee this up before I recognize Mr. Sutherland, this issue was brought to us during the legislative session this year. It's an emerging issue for design professionals across the country. It affects architects, I believe, a little more perhaps than engineers, although it could affect both, and it deals with the issue of intellectual property of design documents and weighing out the distinction between instruments of service, which historically design documents and design models now in the 3D world are and have been, versus copyrighted material, which is developed and provided to owners as an owner's property and copyright. And it's something that I wanted to tee up here. I think it's a good topic to address this summer. I think it's something that, as this committee characteristically does, we want to be very deliberate and thoughtful. If there is a legislative response, consider one. If none is needed, then frame maybe where the solution is and kind of facilitate that solution both for public entities and potentially for private entities. But with that, I'd like to recognize Mr. Sutherland. Thanks for putting this together, and the floor is yours.
All right, good morning, everybody. I am David Sutherland. I'm the Executive Director of the American Institute of Architects. I won't talk long this morning because we have experts who know this topic much better than I do. I wanted to thank the chairman of the committee for having us this morning. It's an emerging important issue that we're hoping to get out in front of in Georgia. A few other states around the country have dealt with it, but we're hoping to be in the front end of that. So architects, like other artists, have a right to the copyright of their work. Like other artists, such as songwriters, they also have the right to sell their copyright. But unlike other artists, architects are a little bit different, and because of the health, safety, and welfare issues of what they do, we don't want a building falling on someone's head. States have an interest in licensing architects to make sure that they're competent to do their profession. So Taylor Swift doesn't have to guarantee that her song is still going to be considered a good song in 3 or 4 or 5 years, but architects have that responsibility. So the issue of whether an architect kept or transferred the copyright for their work was really straightforward in the days of Mike Brady and the Brady Bunch. It was just a set of drawings that were handed over at the end of a project. They were usually rendered by hand or drafting instruments, but over the last 10 or 15, 20 years that we've actually seen the way that architecture products are created has been transformed by technology and science, and that's why we're in this committee this morning. And mostly this is through what we could call BIM technology, building information management systems that help design a whole range of architecture documents, and they've entered into the intellectual property landscape. More and more often in recent years, owners are demanding that the copyrights for these works be transferred to them at the end or even in the middle of a project. As you'll see, this is causing some significant problems on liability, copyright law, and intellectual property concerns. In some cases, the new realities of how this BIM technology is used affects copyright law ownership, and some even can put the viability of some firms in doubt if certain things transpire. So this issue has been emerging around the country. Our national association has been working on it. A number of other states have addressed it. Sometimes there's legislative solutions. So you're obviously hopeful you can work it out in other ways. We want to address the problem in Georgia before it becomes a bigger problem, and we'd like to be a leader in the country on this issue. This morning we hope to provide a broad overview of this topic. We're going to provide some background and also some different perspectives, both from an architect standpoint and from the owner standpoint. I'm going to describe each of the speakers' roles, but I'd like the speakers to introduce themselves and give their credentials before they begin presenting their topic. Mr. Chairman, I'm not sure if we want to do questions, wait till the end, but I might suggest that we do some questions at the end of each, and then maybe save some of the bigger ones when the picture comes together totally at the end.
I think that's a good approach.
Okay, excellent.
And again, as we go, if there's things, as people are speaking, I don't want to have folks necessarily breaking their rhythm, but if there's something factually you need to clarify to understand what they're talking about, don't be afraid to ask. This is kind of an arcane subject for many people, not something that many folks have a strong, frequent command of. So if there is a clarification that needs to be made, don't hesitate. Then we'll move through and ask bigger questions at the end of the presentation.
Sure, fantastic. So we're going to have an overview of the architecture technology that I've called BIM technology first. We're going to have a survey of the landscape of copyright and intellectual property and how it affects the design industry. Then we're going to have a perspective from members of the design industry and how that's impacting their firm and how they do business. And then finally, we're going to offer a perspective from the owner side about why they are asking for the copyright to be transferred to them. And then we'll do some Q&A. So I'm going to ask Sal to come up first. I will say that there are some documents over here. I've handed out her presentation. There are a few other supporting documents we may reference. Those are optional. But if you would like those distributed, and so we actually hold up your presentation.
Yeah,
I put some in front of everyone's seat. Has everyone got a copy of that before we get
do
started?
you need a copy?
I think we're good, Ms. Leilani.
With that, I am done. Thank you very much.
Ms. Leilani, welcome.
Thank you. Thank you, David, and thanks for having us. My name is Sal Leilani. I work at TVS Design, which is a firm in Midtown, and you might be familiar with the old Georgia Dome, the new Falcon Stadium, and things like the aquarium. So I've been at TVS 5 years, but I've been practicing architecture for the last 10 years and been using BIM, which is what we're here to talk about, for about 13 years. So just to give you a brief overview, what we do as architects is our primary mandate is to protect life safety and welfare of the people. That, as far as that is, once we take care of that, we go into other things like we do research and development of products, of building systems, things like that. Of course, there's design. We care about how things look, the composition of spaces, and the experience of the user. We listen to the owner and what they're looking for in terms of functionality of a building, and we integrate that into our design process. We have to consider things like constructability, because eventually, when we finish, what we create then gets passed on to the contractor. And then finally, we act as quarterbacks for all the trades that go into a building. So we're basically the synthesizer of information that we get from the structural engineer, the electrical engineer, other consultants. And although our job is to design the building, we're also relied upon to bring everything together in a coordinated fashion. So what is the language of architects? Our primary tool is graphic representation. We do have narratives that go along with our drawings, but primarily we use image sketches, diagrams, drawings, 3D perspectives to communicate not only to the contractor, but initially to the owner, and get them a sense of what they're going to get. That's how we demonstrate that we've heard the owner, and that's how we demonstrate to the contractor that this is how they're supposed to build the building. So our tool and the technology that we have been using to generate these graphic representations has evolved over time. It started off with parchment paper, where you drew a new drawing for every single project. It then went to ink on Mylar, vellum. We started to do blueprints. And then we got into computer-aided design, which is AutoCAD, you might have heard of, which is still a two-dimensional platform, but it allows us to create some assets that are reusable for the next project, so you're not having to recreate a drawing every time. And that created some efficiencies that accelerated what we could produce in a given amount of time and effort. And then probably around the turn of the century, something called BIM was introduced to the industry. BIM stands for Building Information Modeling, and there's several different software that are considered BIM, the primary one being Revit. And that's the one that I'm familiar with. That's the one that the industry uses. BIM is a three-dimensional software that can integrate different trades, like the engineers and the lighting designers, etc. And it allows all the different trades to work in a common platform that is able to coordinate real-time design of one aspect of the building versus another aspect of the building. So a BIM model is essentially the 3D space in which everyone works. And the fascinating part about the BIM model is that you don't have to have several different models for several different trades. You can all work in the same environment and therefore enable a truly integrated process. So the BIM model can be at different levels of development. So you can use a BIM model very basically for conceptual design. You're just kind of blocking out a space. You are doing massing studies. You're just trying to diagram. However, and then at the other end of the spectrum, a BIM model can be used all the way down to fabrication drawings. So I can load a BIM model with so much information that a steel fabricator can take it and take it to the mill and laser cut something from it. So there's a level of development that we call it LOD1 and then all the way to LOD5, which is sort of data rich, and it's got information about cost, it's got information about area, and really what typically on most of our projects, what we generate at the end of a project is somewhere in between the spectrum. It's not the massing study necessarily, it's not the fabrication drawing. We develop the model to a point where we can hand it over to the drawings over to a contractor to the point where we successfully convey design intent and they're able to go and build a building from that. In the packet that you have right here, okay, there's just some visuals about showing the different levels of development and what that can generate. So at the most basic level, you're communicating to the client what they're going to get. And then as you flip the page, you can see the level of complexity that you can achieve in a BIM model by continuing to develop and add more information and data to it. It's almost like you're building the entire building first in a digital realm. And then finally, so we've talked about the 3D aspect. Eventually, you're able to layer on another aspect, which is time, which is the 4D, and it allows a contractor to overlay scheduling. So it's almost like an MRI for your building that can isolate different components from the muscles, from the organs, and then look at the skin separately. But it gives the contractor the power to sequence a project, which hopefully leads to a more efficient construction schedule. So how do we develop these documents that we're giving to the contractor somewhere in between the schematic and sort of the fabrication level setting of drawings? for example, at TVS, we allocate an immense amount of resources in the office to create a resource library, if you will, so that project managers take from possibly one project to another. In some cases, adapt a certain detail. So, for example, a foundation detail that you may have used on one project that worked really successfully. You may take a piece of that concept, adapt it to the next project based on its relevance, and in the process of kind of moving these things forward, these details become more robust, they become more mature, and it is essentially a digital archive of the firm's experience. And this resource library is essentially what sets one firm apart from the next. It's a reservoir of things that have worked and details that have been edited over time because something did not work. But we build on our knowledge from one project to the next, and that's the reason why we're able to do more and more complex buildings every time. And we can do them faster and more efficiently every time. Finally, I wanted to end with just the concept of sharing the BIM model. It's something, obviously, that we use internally as a design team. There was a project that I worked on in India that it was so large, it was one building, but it was so large that we had 6 different BIM models that were all nested into the site model. And in each model, we had about 10 people working on it. So it's just to illustrate to you the power of the platform allows at any given time over 100 people to be inputting data, and at the end of which you've basically got a reservoir of everyone's knowledge and information and efforts over a course of time into one model. And we're able to share that with the structural engineers, so you're not having to pick and choose what material might be relevant to an engineer. You're able to share the big picture, and they're able to spin the model around. But really, what's great is when we were working in AutoCAD, you'd have different people working in different files. Here, we're all able to work in one model and really see the big picture at all times.
So wanted to follow up. There are a couple questions, Ms. Lalani. So in essence, just to kind of summarize, modern design is creating a 3D virtual representation of the building that the architectural team leads, and that really becomes the tool which is then handed off to the contractor. You can print an infinite number of pages of different cuts and views to be able to build it. But we're no longer producing sheets, we're producing virtual models today, is what's being done.
That's right. And we use the BIM model to generate your traditional 2D drawings as well. So the model is not just it doesn't just allow you to look at it 3-dimensionally. The way the software is developed is you can cut several of these sections and go back to the familiar drawings that you think of when you see a roll of architectural drawings. So it enables both. It enables photorealistic renderings, but also your floor plans and your reflected ceiling plans and things like that. So depending on the project, the contractor at the end gets either the drawings, the model, or both, depending on how the contract is written.
Thank you. Representative Gilligan, question.
Yes, thank you so much for this informative briefing. But one of the things that kept itching my mind and I kept looking for, 3D printing. I kept wondering if you're taking these 3D models and making the 3D print so that you can...
That's a great point.
...touch.
Absolutely. 3D printing, you can certainly take one of these models, and like I said, there's different software that are considered BIM. Several of them are very specifically tailored to end in a 3D printing result. So Rhino, for example, just to throw out some names. But yes, 3D printing is still early when it comes to building construction and how it's applied there. But absolutely, because you're three-dimensionally modeling this, you're skipping several steps between what you're doing on the design platform and what you're hoping to 3D print.
Well, I guess in a follow-on, if you don't mind, sir, what I was thinking is obviously traditionally there would be a model that people would physically touch, but now you can do exacting models that someone can touch and remove the roof and actually see the structure inside should they desire to print that level of detail and see whether or not this is really going to work. And so I was curious if that's the level of the modeling that could be expected or is even being done
It is.
today. Okay.
It is, absolutely. You have the information in the model to be able to do that. Typically, a real three-dimensional model, a physical object, is built to represent sort of the composition of the building and not necessarily to check for clash detection and things like that. That's typically done more in a digital space. But yes, the information is there, and you can print as many pieces of it as you'd like. But just to go, anytime we build a physical model, it's really more of a sculptural exercise than a coordination exercise, if that makes sense.
Yeah, I was just curious. Thank you.
And just to clarify, clash detection being, making sure there's not a structural column that's running right through where a piece of air conditioning duct is running. The ability to get special cutaways allows you to look in and see and do that in a much more mature way on the current environment. Representative Braddock.
Thank you, Mr. Chair. So I guess swinging this back around to the intellectual property piece, I guess it's kind of there's so much collaboration and evolution and information and data and everything that's being shared. So, like, how do you see this swinging back around to the intellectual property ownership of who actually owns? I mean, what are y'all looking to do with that? And how are you wanting to change? Because it's kind of hard to sort that out because it is so collaborative. And
no, that's a good question. And I'm hoping that the follow-up speakers are going to get more in, go into a deeper dive on that exact topic. But I guess what my mandate here is to explain to you how we as a trade use BIM and how we have been able to leverage it to gain efficiencies and communicate better. But with communicating better comes the risk of over-communicating, I guess, and I think that the people that are going to speak after me will address that a little bit closer.
So, well, whoever has this information, if there's any case law or anything you can outline for us about how it's currently being handled and what the latest cases are weighing in and saying, now that things are evolving in this space, that would be helpful for us to know.
We'll get there.
Okay, thank you.
One last thing I'll say, just follow up, if you see how does the industry use BIM, I think Ms. Lilani's slide is a great one. It shows a construction professional on a job site with a tablet computer, the ability to take these details and refine more and more and provide more and more information through technology on the job site as opposed to rolling out big 22 by 34 drawings on sheets of paper is a value added to clients into public safety in the industry. And I think the ability to do that, again, those little plays you call in a playbook, you want to use again and again. I mean, the Falcons used the same play the second game of the season that they used in the playoffs in many cases. So perhaps they should. But we may refer back to some of these things. But again, Ms. Lilani, I appreciate your technical presentation. It was right on target.
Cool.
Thank you.
Thank you.
Appreciate you. Next, we've got Mr. James Trigg from Kilpatrick Townsend to talk about copyright law. Mr. Trigg, welcome.
Thank you very much. Good morning, everyone.
Good morning.
So I'm James Trigg, and I am a counsel with the law firm Kilpatrick Townsend here in Atlanta. I've practiced intellectual property law there for over 21 years, and I specialize in the areas of copyrights and trademarks, where I represent a variety of businesses and individuals, including architects. In my practice, I've worked with architects and architectural firms to assist them with issues relating to the registration and protection of their intellectual property. I've also litigated cases in which I have assisted clients seeking to enforce copyrights in architectural works against infringers. And I've also been called upon to defend clients against accusations of infringement with regard to works of architecture. In addition to my work as a practitioner, I've taught classes in trademark law at the University of Georgia's Law School, and I've taught copyright law at Emory Law School. In addition, I've served as the president of the Southeast chapter of the Copyright Society. I was approached by the Georgia chapter of the AIA to provide this committee with testimony on the subject of copyright law and how it applies specifically to architecture. My role today is simply to offer a legal context for some of the points that the other speakers will be making. I'm not here as an advocate for any particular position. I want to educate the committee over these next few minutes on the following points. First, what is copyright and how does it protect the work product of architects? Second, what are the default rules under the law for determining copyright ownership? Third, what are the ways in which an owner of copyright can transfer his rights to others? And fourth, what rights does the owner of copyright have against others who, without authorization, utilize rights protected by the copyright? As I discuss these points, I'll try to use examples that tie these points back to the architectural field. So let's start with the question of what is copyright and how does it protect works of architecture. Copyright law in the United States is governed by the Federal Copyright Act, which governs the creation, use, transfer, and enforcement of original works of authorship. The Act lists examples of the types of works of authorship that our law protects. These include literary works, musical compositions, sound recordings, and motion pictures. For the architectural profession, there are two categories of works that are particularly significant. First, the Copyright Act offers protection for pictorial, graphical, and sculptural works. This category of works protects technical drawings, and it includes the blueprints and the visual renderings that architects create when they work on a project. Now, once upon a time, those blueprints and visual renderings were Mike Brady, as Mr. Sutherland referred to earlier. Those blueprints and visual renderings were created by the Mike Brady sitting in his studio and preparing a physical blueprint. But as Ms. Lalani just described, that process now largely takes place on a computer via a computer program. And the fact that now the drawings and renderings are created in a computer program and not on paper doesn't affect their status as protectable works of copyright under the law. A second category of work that the Copyright Act specifically offers protection for are architectural works, which are defined as the design of a building as embodied in any tangible medium of expression, including a building, architectural plans, or drawings. You might think to yourself there sounds like an overlap between those two things, but what the protection of pictorial, graphical, and sculptural works protects, it protects literally the artist's drawings, the architect's drawings for a particular project. These are drawings actually that I used in registering a copyright for technical drawings for a client. The architectural works copyright actually protects the look of a finished building. So in addition to an architect being able to protect his or her drawings and renderings, the architect can also protect the copyright in the overall look and spaces of a physical structure. I don't mean to suggest that drawings and completed buildings are the only types of copyrighted works that architects create. In the course of a job, an architect might create any number of other things that could be protected by copyright. For example, she might make short animated videos that show a flyover of a building site. She might take photographs of a job, and those photographs of a job might be included in her deliverables. She might write a computer program that's used to prepare a certain solution to a problem that the architects are having on a project. All of these creative works could be included in the deliverables that an architect supplies during the course of a job. I want to emphasize also that copyright doesn't necessarily protect every feature of an architect's work. To the extent, for example, that a building contains commonplace features like Doric columns or windows that have a particular historic look or a common floor plan, these elements of a design would not be considered part of the copyright. Copyright exists to protect works that are original. So elements that might be drawn from the public domain are not considered protectable under copyright law. So now that I've given you an idea of what copyright is and what it protects, I want to talk about the rules for determining copyright ownership, the default rules. The basic rule of thumb for determining ownership of a copyright under U.S. law is that the author of a work normally is deemed the owner of a work. In other words, generally speaking, the person who creates the work owns the work. Now, a wrinkle on this basic rule that I just gave you is something called the work for hire doctrine. A work for hire is defined as a work prepared by an employee within the scope of his or her employment. Let's say that Tony X architecture firm is hired to design a building, and 3 designers at his firm work on the project. Those designers' contributions to that project on behalf of their firm would be deemed automatically owned by the firm by virtue of the work for hire doctrine. They are employees who are working within the scope of their employment for Tony's firm. Keep in mind that under the work for hire doctrine, employee really means employee. It does not cover the work of independent contractors. This is very significant. Let's say that Tony's firm engages an outside lighting designer to prepare drawings for a lighting scheme for the building. The work for hire doctrine would not vest Tony's firm with ownership of this designer's work product. Why? In this example, the lighting designer is an independent contractor. He is not Tony's employee. If Tony's firm wanted to confirm ownership of the work of the lighting designer, it would need to arrange for the lighting designer to convey the copyright to Tony's firm. And I'll talk more in a couple minutes about the transfer of copyright ownership and how that works. In a similar vein, a developer that hires an architecture firm to design a building for it does not presumptively own the copyright that the architecture firm creates. In virtually all circumstances in which an architectural firm is engaged by a developer, a property owner, or a governmental agency, the architect is acting as an independent contractor and is presumed to retain their own copyright unless the architect and her client come to a different agreement. This leads me to the next topic I want to address. We've discussed what copyright is, what copyright protects. We've discussed the default rules for ownership of copyright. I want to now address the ways in which copyright can be transferred. A grant of copyright can take place in one of several ways. First, a party can convey the outright ownership of copyright to another party. The transfer of copyright ownership requires, under the law, a written document. Other than the work for hire situation that I discussed a minute ago, there is no such thing under U.S. law or under any other law that I'm familiar with as an implied transfer of copyright ownership. There's some history to the reason why this is the case. The framers of our current copyright law, which was enacted in 1976, were mindful of protecting rights of creators, and they were sensitive to the potential for abuse when larger, more sophisticated parties entered into deals with artists and creators with more modest means and less sophistication. Accordingly, the Act was crafted to make clear that an explicit written conveyance would be required to divest an author of its copyright. A copyright owner can also grant rights in a copyright in the form of a license. With a license, the copyright holder retains its ownership of the copyright, but allows another party to exercise certain rights under the copyright pursuant to terms that the parties negotiate. A copyright license can be exclusive, it can be non-exclusive. In the case of an exclusive license, again, the terms must be in writing. A non-exclusive license, on the other hand, can be written or oral. It can even be implied through the conduct of parties. Licensing can become quite complex because licenses can take innumerable shapes and forms. For instance, a license can be defined in terms of geographic territory. An architect might grant a developer the exclusive license to use the architect's work on a particular project in the state of Georgia, but nowhere else. Licenses can be defined in terms of time. For example, a songwriter might grant an advertiser a 1-year license to use her music in an ad campaign, but not 1 day longer. There are countless other ways that a license grant can be crafted. Also, I want to note that many transactions can take a hybrid form, where certain rights are conveyed outright and where other rights are held back and licensed. Software programming is a good example of a field where this happens routinely. Software developers typically come to a job with certain pre-existing work product that they use time and time and time again on the jobs that they do. But also when a software developer is engaged on a job, there's often unique, discrete code that is written for that project. It's not unusual in contracts governing the development of software programming, custom software programming, that the software developer might convey ownership to its client of any unique work product developed for that project. But the software developer holds back ownership of its pre-existing work product and simply grants a license to its client to use that pre-existing work product. So I've talked about the subject of what copyright is, how we allocate ownership, and how rights are conveyed. I want to conclude by saying a few words about what rights a copyright owner enjoys. The owner of copyright in a work has the exclusive right to do or to authorize several things. She can reproduce the work. She can distribute the work. She can make derivatives of her copyright. Derivatives are new creations that are based on versions of an earlier work. She can display the work, and in the case of certain types of works, she can publicly perform the work. Stating that point another way, a party who creates a work and then transfers its ownership cannot do any of the foregoing things, at least not without the permission of the new owner. It is indeed possible for an author to be sued for copyright infringement for infringing rights in a work that he created but transferred to another. There's a famous copyright case in my field that involves the singer John Fogerty, who some of you guys may know was the leader of the 1960s rock group Creedence Clearwater Revival. When Fogerty was in Creedence, he transferred ownership of all of his songwriting rights to his record label. Years later, in the 1980s, Fogerty wrote a song called The Old Man Down the Road, which became a hit in the 80s. Fogerty got sued by his old record label, who said that The Old Man Down the Road sounded too close to some of the songs that he had written when he was a member of Creedence. Fogerty ended up winning that case on the ground that there was not a sufficient similarity between his new song and his older songs. But like a lot of copyright cases, it could have gone either way. And the case illustrates the risks that a creator faces when he sells his copyright to someone else. A party who commits copyright infringement can be subject to a range of penalties. First, the plaintiff can obtain an injunction that prevents further use of the work. Second, the plaintiff can recover its actual damages from the infringement, as well as the profits the infringer receives from the act of infringement. In certain situations, the plaintiff can recover fixed damages known as statutory damages, which can range as high as $150,000 per work infringed. And finally, under certain circumstances, the plaintiff can recover its attorney's fees incurred in litigating the case. So there are real monetary and practical consequences to copyright infringement. There's a lot more that I could say about this topic. There are indeed entire law school courses that are devoted to the subject of copyright, but I hope that the points I've made today are sufficient to at least give you some context for some of the issues that the other speakers are addressing when they discuss ownership rights and architects' instruments of service. And I'm happy to take questions now, but if you don't have any questions now, I do plan to be here for the duration of the hearing in case questions arise later on. Thanks.
Mr. Trigg, thank you. I do have one question from Representative Rakestraw.
Thank you, Mr. Chair. So initially you said something about the renderings and the drawings. So is there a caveat in there that they have to be hand-drawn? I mean, how is it affected? How is it affected when they're actually digitally produced versus hand-drawn? Does that impact?
The Copyright Act is completely neutral as far as the medium in which the drawings are created. And as long as the drawing is created in some form that can be perceived visually, it's protectable under the law. So whether it's Mike Brady cranking out a blueprint on paper, or whether it's Sal Lalani creating a visual rendering in a computer program, either way, those drawings are equally protectable.
Okay, thank you.
Following it up a bit, if I can. So if I were to draw something on here and want to copyright it, pull it off, we get with you, make copies of it, and you take this to the office or you file the copyright with us. I'm a bit familiar with software, and I had a client one time when we did the backup, and there was the backup takes. He said to me, "How do I know it's on there?" And we all get that with electronic media. What would one copyright in the present? And we may be getting there later, and that may be part of the, why we're here. But in this BIM software, I mean, it's going to have some sort of data file or combination of files there or that tie all together. So if I were to have this thing and I use BIM to, well, we'll just use the stadium over there, okay? What do I ask to copyright? Do I copyright that building? Do I copyright? Is that why we're here? Do I copyright the process by which that mechanical roof closes in case that's used on another building? Do I copyright one of them separate from the other?
Sure.
Is that why we're here today?
When I work with an architectural firm to register a copyright, and incidentally, I want to point out that you don't have to register a copyright to have a copyright. Registration is, for a variety of reasons, a good thing to do. It gives you certain additional protections for your copyright, but you have a copyright once you have created something, whether or not you register it with the U.S. Copyright Office. But having made that point, when I work with an architectural firm to register copyrights, we're typically interested in protecting two separate things. One, we're interested in protecting the underlying visual renderings that the architect has created in the course of designing the job. So that can be floor plans, it can be building elevations, it could be 3D renderings that are embodied in some kind of computer program. And that's the subject of typically of one application to the Copyright Office. Separately, once the building is built, we will typically file a copyright application to protect the entire finished look of the structure. And those two separate copyrights give the architect kind of separate sets of rights against potential infringers. The first one that I described protects the architect if someone somehow gets their hands on those drawings and misuses them or reproduces them without permission. The copyright in the finished structure protects the architect in case someone who's a skilled draftsperson goes to the building itself, creates a sketch of the building, and then builds something based on the copy of the structure itself. We're getting kind of down into the weeds, but those are typically the things that I'm thinking about when I want to try to give my clients the broadest range of protection in their IP on a job.
So if I may just brief follow-up, so that would go so far as to trying to recreate the physical building itself, but also I've been to various Olympic venues in Beijing, China. There's the Olympic stadium they have, and you can go over there and buy little various things to bring back. Those things would fall under if the architect or the owner of the copyright for that stadium, if that were in the U.S. I know it's different in different countries, but that would fall into if you were going to sell an image of that or a drawing, or even you could argue in some cases official photographs. If we're going to sell those, you could arguably be infringing upon someone's copyright. If you really made a nice picture of an Olympic stadium,
Sure.
and somebody said all of a sudden I want to reproduce those photos, you probably need to go and work with the copyright with the architect, correct?
You possibly would. There's some photography has some slightly different rules associated with it, but one of the things you hinted at was maybe if you wanted to buy a 3D replica,
Right.
like a little miniature 3D replica,
That definitely has to.
that would unquestionably fall within the architect's copyright.
Thank you.
Mr. Trigg, I appreciate the presentation. Again, just by way of explanation for the committee, we've sort of set the stage for the presentation with Ms. Leilani's sort of explanation of the practice of architecture and modeling. Mr. Trigg set the legal context. Now, our next presenters are really going to kind of get into the thrust of our legal question today. So, Mr. Trigg, thank you.
Thank you.
Chair would like to recognize Tony Eck and Jay Silverman. If you guys want to take either side, that's great. Again, by way of introduction, if you guys could just sort of introduce yourself and,
Sure.
and kind of how you got here and sort of tee it up for the committee members, if you would, please.
I'm Tony Eck, and I will lead off and then be followed by my colleague Jay Silverman, and I think we're going to tag team a bit. Interestingly, as a segue to what you just described, a few years ago, we took Miss Freedom off the top of the Capitol here with a helicopter, landed her in GBA 1 parking lot, scanned her, sent her to be repaired, put her back up, and when it came time for the Christmas season, we transferred our copyright to Miss Freedom to the Secretary of State's office so they could make Christmas ornaments out of Miss Freedom. Our contract wasn't explicit on that, so we did it affirmatively, but it was interestingly. I will.
His architectural drawings for the Capitol were developed by a helicopter flying around the building because there were no original drawings.
Before drones. Well,
For-
thank you. My
For the record, Mr. Eck himself did not design this building in 1884. Of course, that goes without saying.
Well, thank you. I'm Tony Eck, as mentioned. I'm a principal of the Lord Eck and Sargent architectural firm. We have 6 offices in the eastern part of the United States and have worked in about 40 states. I'm registered in multiple states, and I've been practicing somewhat longer than Sal and James. I won't be more specific at the moment. I've been past president of the Atlanta chapter of the AIA. I was on a member of the committee that wrote the state construction manual. I'm currently on the faculty of an owner group, the Owner Training Institute of the Construction Owners of America Association. And I also wear the hat as owner on a couple of building and ground committees, which I chair for not-for-profit entities. So I hopefully have some perspective, not just the profession's perspective. Jay and I were asked by the AIA Georgia to discuss intellectual property and evolving trends and impacts the transfer of intellectual property can have on the profession. And so my first part of this will be to speak briefly about what we frequently are being confronted with or requested to do in contracts from both the private and public sector at all levels. And then Jay will be speaking a bit about some of the issues that come about through rights that we are asked to transfer. And then I'll come back and discuss some about potential solutions that might provide for meet both parties' needs, that is, private public sector clients as well as the design profession's needs. And I would say largely that what I'm talking about would apply to not only architects but engineers and specialty consultants that have registration as practicing professionals. So starting, here are what we are frequently seeing ask of us with respect to contracts. Number one, that we see clients desiring to own all the intellectual property associated with the project that we have created and our consultants create from the moment it is created. And I'm going to just read two brief passages from two different contracts I've seen in the last week, and that'll be the only thing I'll read at any length. One's medium and one's very short. Here's the first one. All work product, information, data, or documents produced hereunder by the consultant and his consultant shall be delivered to the client, and title thereto shall vest in the client regardless of the stage to which the development of the study may have progressed. In addition, the consultant hereby expressly assigns, transfers, and otherwise quit claims to the client. Its heirs assigns forever all rights, title, and interest, including all copyrights and all termination renewal rights in such copyrights, and all causes of action accruing under such copyrights in all studies, study calculations, drawings, specifications. I don't think I can keep going, it's too painful, but I'll go to the end sentence. The consultant further warrants, that's me, that this transfer of copyrights and other rights is valid against the world. Finally, reproducible copies of all work products and other technical data shall be furnished to the client without cost, whether the work for which they are made be executed or not. That's a fairly robust transfer of rights that I think Mr. Trigg explained were traditionally rights held by the originating design professional. The second, much shorter version, the architect hereby grants, assigns, transfers, otherwise quit claims to the owner without reservation all copyrights to all project-related documents, models, computer drawings, and other electronic expressions, photographs, and other expressions of instruments of service produced by the architect. So you can see it's a fairly robust request to transfer these rights. Second kind of thing we see associated therewith, clients sometimes desire to be able to do whatever they want to do with these rights, and in other cases they voluntarily, or at least through contract, limit their use rights, and in some cases even agreeing to hold the design professional harmless for certain applications which extend by the beyond the original project. That is to say, we might design the building, but they want to build the building elsewhere on multiple occasions, or add to it, put another story on it. In those cases, sometimes we are granted a hold harmless. The third kind of thing we're seeing, clients usually agree that we may retain copies of the intellectual property for our records, and in some cases they license back, as indicated as possible, broad rights that we can enjoy. In some cases, those rights are not fully intuitively understood by us to be exercisable. That is to say, if we're transferred a right back to utilize our work product, to transfer it again and to sell it, it's not clear to us how we can sell something that we've already transferred the rights to the first party. But that's, I'm getting a bit in the weeds. Fourth, clients usually want the design professional to indemnify, hold harmless, and defend clients against all claims alleging the design professionals have infringed copyrights or patents of others. That seems, in a sense, a reasonable request. I'll speak more to it at the end. But increasingly, as you heard from Sal, manufacturers, vendors, others are preparing elements in computer-aided design form which they give us because they want to see them incorporated into projects, and we don't own copyrights to that, for example, but we don't typically expressly go out to every lighting manufacturer and say, please send us a license to use your element in our design. So this is another area where we have certain concerns when that copyright issue, or when that issue's incorporated in contract. Lastly, in the general kinds of issues that we're seeing, the above demanded rights, that is demanded by contract, are sometimes not explicitly contingent upon the clients fulfilling their contractual obligations under the contract, which include, among other things, paying the fee to the architect. And out of respect for some of the folks in the room, I'm probably talking more about my private sector clients than some of my perhaps my public clients that tend to be very good payers, as it were. At this point, I'm going to ask Jay, if you would, to talk more about issues.
Before we go there, are there any questions for Mr. Eck?
Happy to provide.
I would ask you, I don't know that you want to dare, or do you have any interest in sharing from whom those contracts came?
You know, I don't know that I can actually tell you right now, because what I did is I put a bunch of them and clipped last night, but I will be happy to do so going forward. And in fact, I can provide electronic copies and answer that at the same time.
And I asked that question just in the context of, there's discussion about, who's doing this to
Right.
design professionals, or who's asking this. Are those folks, is this calculated and intentional? Is it just sort of language that, I know from my corporate days, you hire attorneys to write standard contracts for you, and they're always written in your favor.
Right.
Is this just a matter of education, or is this a matter of, hey, there's a real calculated intention by a government agency? I don't know that local governments are doing this, but they could have borrowed a contract from somewhere else, and it could be working its way in. So I want to just kind of understand the scope of this.
Well, I'll give you a very brief answer to that. I think to some degree there is a perception, particularly on the part of public owners, that they are institutions that are here today, will be here for a long time. They have responsibilities to the public, and they feel to protect that right or the project, they need to own this. I believe, and I believe Mr. Trigg demonstrated it, that we can provide a solution to their need to perform their fiduciary or stewardship responsibilities without taking the actual copyright, which does create downstream consequences for us. So I don't know if that's responsive, but
Well, no, it is, and I'm going to recognize Representative Martin for a question in a moment. But the idea of a facility management process that wants to have a model that can look at, to be able to look at all the electrical panels perhaps in its building to say, hey, there's this safety message that came out. We want to recall these panels. And to be able to have that electronically, I can see as an owner would be helpful.
Right.
I don't know. It's immediately apparent to me why they would need to hold copyright to prevent the architect from being able to reuse or have access to that. So I wrestle with this. I think public owners have an interest in having full access to what they've paid for, but I don't know that denying the architect access is clear to me why that's important in the same way. But Representative Martin.
And again, I don't want to get too far down because we have a schedule to keep, but I guess I'm trying to get my hands around this, and I'm going to relate it back to years. I haven't been for years, but years ago I was in the software business when things were coming out, and when software even on the microcomputer was $4,800 until Philippe Kahn came along and so forth, and to get in that, and we wrote software and we licensed software, and there were different types of things that we did out of MSA that we gave people worldwide non-exclusive rights to take our code and do whatever they wanted to, and then they paid us royalty back. My question is why couldn't this work here? I could see myself if I were a government building and you had designed something for me, you may take the bones of that building, if you will, and put a different facade on it and build it in another, for another town hall. It may not be just like that. So is it not, I can see from what a city would want then is if I'm paying you to draw that building and I want you to convey all the rights to me because I don't want to get in trouble one day for having the guy come in and modify that after you may be gone, and then I violated your copyright by giving your plans to somebody who's doing an addition. I see that from a city perspective. From your perspective, it would seem like if you're not required to give away the copyright of that building, you could do it perhaps for less money because you get to keep that base bones building to do again. Has there been thought, or again, is this where we're headed to from a legal standpoint of being able to provide a limited access copyright? Because what we used to do in our language would provide you a right to use or a right to modify for this specific purpose. Right. Is that available today? Is that what we're having some confusion with, and we're trying to split hairs of what part of that are you conveying if you're providing a limited access or a limited right to use?
Architects are in a service business, and we're in the business of responding to client needs. So part of our presentation, particularly the last part, will speak to the fact that if you want all kinds of rights to reproduce this building in 10 states, to add to it without our involvement, there are mechanisms whereby that can be conveyed so that you can accomplish your needs and goals, while at the same time we can also
do the same
enjoy
thing. Right.
our ability to, for example, use that intellectual property we've developed over a period of years for the next time we want to do a good door detail. So I think we can come back, and that's where we're headed to, is trying to create the win-win situation. Right now we feel there are some, by this predominant view that it needs to be transferred, it's beginning to put us in some binds that we would rather not be in. I hope
Okay, I'll wait. I mean, I wonder why contracts between private parties can't do that, but I think we're going to get to that later where they feel some pressure from certain entities to do it. So I'll wait for further questions later.
Thank you, Representative Martin. Mr. Silverman.
Thank you. I'm Jay Silverman. I'm also a past president of the Atlanta chapter of the American Institute of Architects. I'm also currently a board member of the Urban Land Institute, another organization promoting leadership in the built environment. And as well, I'm a principal with Dwell Design Studio. We're an emerging architectural firm. My experience goes over 20 years, and I've worked for both public sector and private sector clients. However, my firm today is currently operating in the private sector. We have offices here in Atlanta as well as in the DC market, and we're doing projects around the country. And I think I'd like to start by following up on the question that was raised. I think that the reason that we're here today is that there is a distressing trend in the industry from both the public sector and private sector, putting language like this in contracts to request copyright for designs when they're hiring design professionals, and whereas in the past just getting licenses or that form has been more than acceptable. Speaking for my clients, they seem to really want to today protect either the look of a house plan that they design to sell, or we design for them that they're selling in their neighborhood, and they want to differentiate their product. They may feel the same way about either apartments or condominiums or hotel rooms. So that aspect of the project, they don't want to see us reproduce in multiple places for different clients. They think that differentiation is important. And then we're also seeing that like was previously mentioned, that they want that ability to have both physical and electronic documentation that they can use to better maintain and manage their building, development, campus, or community. And they're, for some reason, which I can't really speculate on, feeling the need to request copyright and ownership of the documents, both physical and electronic, to accomplish these objectives. But John, who's going to speak more behind me, may address these issues in a little more detail. I'm going to talk about a few issues that we're seeing with architects or design professionals losing copyright to their intellectual property. First and foremost, we see that they lose their ability to protect public health, safety, and welfare. As Sal mentioned earlier, the building information model and the electronic documents are a product, and the ultimate goal is to develop a building. And so sometimes during the construction process, issues arise, or there may be specifics to the actual building to address life safety challenges that for some reason may not be captured in the building information model, or there may be a nuance very specific to the project as it was constructed that addresses a life safety issue. And so we don't want to see our building information model taken and reused in a different context and lose some of that protection without our involvement. The next item is that requirements to transfer the rights of our work can put out incomplete or inaccurate information. I think that as Sal mentioned, there are levels of information that can be included in the building information modeling, and that can vary by project or limitations of technology at the time, or schedule, or other, again, project-specific factors. And so as an industry, we've typically not been required to release the product, the in-progress product before, and especially not in a digital means like this that has some the ability for somebody to take it without getting the full range of our service, and use it without our involvement in a more different way, because it is, again, you're taking maybe a partially developed computer model and using that to build a building, or bring in another design professional to complete that. The other challenge I think Tony already touched on is our ability to reuse intellectual property that's been developed over an extended period. And Sal touched on this as well. She and her firm have a library of elements that they've developed over time. It's part of their expertise, developing these complex, high-profile projects, and it's why clients will go to a firm like that or go to a firm like Tony's, is because they know that he's done this before and she's done it before, and they're bringing not just their knowledge but also some of the digital information, and so having one client come in and use the information and knowledge that they've built over time, and then through a difficult contract claiming copyright over that, we think is, and then saying, well, you really can't use that in the future. And it's not just her, it's also the engineering team behind her. And so that's an important aspect of that we wanted to bring out. The other item that's related to that is giving away copyrights to intellectual properties without control can also impact the rest of the design team. For example, a structural engineer may develop a really unique way of solving a technical challenge that related to, for example, either parking structure or a wood frame building, that the manufacturer of the wood joists or the manufacturer of trusses or metal trusses can take, because the structural engineer has given their rights to the owner, then the owner owns the rights to these details that this engineer spent their time and effort producing over time, not just for this project, and use those. And then the person to enforce those rights wouldn't be the engineer, it'd be the owner, and the owner is in a different business, and so they're not affected. So that company could effectively take these details that my engineer or Sal's engineer or Tony's have developed over years and reuse them without either compensating them or involving them. So we're especially concerned about that, and technology has some amazing strengths, but a disadvantage is the ability to disseminate information and not know who's involved. Moving on to just stay on schedule, we really I think I'm touching in that point about inappropriate reuse or multiple reuse. We can also see clients do that as well, and have concerns about that from a technical standpoint and a life safety perspective. And then my last two items are that rights transfers can reduce their ability to working with other clients. I think that by allowing these difficult contract provisions in our state, as building information modeling technology improves and increases, and our ability to 3D print buildings or components of buildings becomes prevalent, I think that we want to be able to have the rights to that information and the control to protect life safety and fulfill our responsibilities in the process, and keep in everyone's mind that the end product of our work is the building, not the building information model. Just as in the past when Frank Lloyd Wright was doing his drawings, the buildings are what we know him for, but those progress drawings were his during his process. And then just to wrap up, I think that we're also concerned from a business perspective that clients, either hopefully not public sector but private sector, if they have the building information model, they may not feel like they need to pay for the balance of their services. They may say, hey, I've got 90% of your work, I own this model, I'll take it from here, Mr. Architect. We've got it. And we lose that ability to collect our fees. So I think that we're just looking for some further assistance with these specific areas of concern. And I'm going to turn it back over to Tony Eck, unless anyone has questions about this, or we could wait till the end.
I'm certainly sensitive to time. I don't want to take Tony's kind of wrap up. So
this is a wrap up, and I'll try and move very quickly. And this is really, I think, a view that we've developed that we believe could meet both parties' respective needs, that is clients, public and private, as well as the design professionals. One, we believe that the design professionals should retain the ownership of the intellectual property associated with the projects from the moment it's created. That is, that it would remain with the originator. We think the 1990 Architectural Works Act contemplated that as the default. It said that, in fact, if you want to make it different, you have to do so in writing by contract. So we think it doesn't rise to public policy that should always be the case, but it's certainly an implication that that's the thought. Number two, we think that the design professionals should grant perpetual licenses to clients to use the construction documents for construction of the project, for the operation of the project, for the maintenance of the project. That's the core service that we render. And we think that that perpetual license, I would call it irrevocable, but there would be one condition or two conditions where I think it needs to have some governors on it. One, it's long as the owner meets their contractual obligations, including paying for the just services at the end of the day. The other one is that we not be terminated for the convenience of the owner. That is to say, we work on it, we develop the big idea, we solve the problem, we're partway done, and the owner terminates us for convenience and turns it over to another party to finish without our involvement. In that case, we don't think they should have an irrevocable future license without some opportunity to negotiate that parting. It doesn't mean we wouldn't agree, it just means we have a stake that we would like to have an opportunity to negotiate that parting. 3, the design professionals should agree not to reuse the original designs without the client's permission in whole or in substantial part, but may freely create derivative works or reuse lesser parts for future clients or future projects. That is to say, we're not going to get paid by you, design the project for you, and then go down the street and sell it to your competitor. We want to let you maintain the originality of the thing you've paid for, but we do want to be able to use some of these details and components that we have developed over time that are not that compelling to the overall vision you're building. 4, we believe that additional license rights should be subject to negotiation and mutual agreement of the parties. That is to say, if you want design models, then we should talk about what's the purpose of those design models. What are you going to do with that? Traditionally, the way a building gets built is with contract documents. Typically, a design model isn't a contract document because they're not typically developed to the full-blown level. So, but that's not to say we want to deprive you from the use of it. It just needs to be a point of discussion and contracting as to what that right is. The second one would be the use of our electronic documents by contractors to develop submittals and shop drawings. We are continually, frequently approached by subcontractors to give them our information so that they can develop submittals for the project. It takes time, it takes effort for us to explain those things to them, to be compatible with their software. That's an issue that we want to talk to the client about. Do you want us to do that? Is that a service you want us to provide? We're happy to do so, but let's talk about it and determine what it is. The use of the original designs for future modifications, additions, or site adaptations. We would like it to be part of our discussion, our contract, our negotiation as to what rights relative to those 3 things do you want. Do you want to reproduce it 18 times? That's a different kind of situation than doing it once, for example. And lastly, again, do you want to use our design? Do you want to be able to terminate us at any point for convenience and use our material? Then we need to have some protection at that point that you don't just having the intellectual property have the right to do that and walk away. The last 2 things, client should indemnify and hold harmless the design professional for any modifications, additions, or site adaptations of the original design without either the engagement of the design professional to interpret their design or if we're terminated for convenience prior to its completion. That's a topic that is certainly a negotiable one with us, but it is not, should not be a foregone right without further discussion. And then the last one would be that we, the design professionals, should indemnify the client for damages, including reasonable attorney's fees caused by our infringement of patents or copyrights. We should protect you if we infringe somebody else's design. It's just we'd rather do that based on your actual damages and your reasonable attorney's fees, not just some allegation that we did something that we may not have done, and then we have to hire the attorneys to defend the client before an adjudication has happened. So, long story short, we believe through the process of granting perpetual licenses for those rights that owners want, that both the owner's needs and our needs can be compatible and harmonious, and that's the better way forward given the changing technology.
I do have one question, but I'm gonna ask direct one to Mr. Trigg.
Please.
Ms. Direct laid out a pretty expansive list of items. Anything that stands out to you there as being outside of the legal mainstream, or is that a reasonable approach to it? I mean, how would you characterize kind of what he presented?
Well, you know, the Copyright Act itself is really neutral on all of these things. I mean, the Copyright Act contemplates that parties contracting with one another at an arm's length can agree between themselves as to anything they want to agree to. So the things that Tony is describing, these are all things that I see in contracts not only dealing with architectural works, but for music and film and literature and photography and all other types of works. I mean, I think that these are all solutions that parties negotiating at arm's length theoretically can come to. And I think the Copyright Act recognizes, you know, the almost infinite numbers of ways that people can solve problems.
And in the private sector, I guess it just ultimately comes down to who's perceived to have leverage in the relationship and in the engagement.
Correct.
The question is, on the public sector side, is this in keeping with the public's, is it really serving a public good, or is it in the balance? I mean, I do think there's a real kind of a bifurcation of this issue. There's a public sector question, and then there's a private sector contract law question. And as long as it's not an unfair business practice, then, you know, maybe it's open to parties. Chairman Martin.
All right, this is a place where I haven't used it since we got out of session, so I'll use it here. You know, I'm not an attorney, and I didn't stay at the Holiday Inn last night, but help me out here, because Chairman brought us in between, because all of those things you talked about to me are contracts between private parties. If I want you to draw something from me and I'm going to pay you X, and it's a work for hire, and I own everything you do while you're doing it, and you can tell me, okay, that cost $1 billion, and I can modify my expectations or pay you the money. Are we here because you feel like you're having a gun held to your head when you're doing public work? I mean, I don't understand. I don't understand the question. I mean, if all those things seem to me to be negotiations between parties to get something drafted.
What are you asking of us?
Yeah, what are we trying to do? Yeah. What's the ask?
I was asked to come speak about what industry or what our design professions are experiencing today in both the private and public sector. And we're experiencing the transfer of copyright creating some downstream problems for us. So I think our principal message is we think there is a way to meet both the client and the profession's needs by not doing that transfer of the copyright itself, but by having specific licenses transferred that meet the parties' needs. And that's,
is the state of Georgia requiring you to transfer that today, or are you deciding to do that in your contract?
Many public agencies are requesting are insisting we transfer it, to answer your question. Many public agencies
Then if
do.
it's not good for you, don't do business with them.
Well, we'd prefer to do business with them.
Then make them come.
We do
I mean,
business.
it seems like
We do business with them.
I understand, but what I'm trying to get to, I mean, if I were doing something and I could do it with a private party or a government, if it wasn't good for my business to do it the way the government wanted, I would just pass.
Yeah. Well, I understand, but for example, the Board of Regents and the Georgia State
there
Finance
you go.
Investment Commission have a Contracts Alliance committee. That committee has worked on these kinds of issues, and as an example, the GISVIC contract is quite good. But it's gone a long way trying to deal with some of these issues, but it's still foundational element. It does transfer copyright. We're simply saying that we think it may not be necessary to do that to achieve what they need, and if we can do that without creating downstream problems for us as a professions, we'd rather see it done a different way.
And my question, and I don't mean this to be adversarial at all, but my question is, if you believe that to be the case, I mean, if all the people in the business believe that to be the case, then the Board of Regents wouldn't find anybody that would draw any plans for them unless you did it. I mean, is there always going to be somebody that's going to do it their way? That seems to be a. I don't see me personally, and again, we're early on in the process, of me legislating a requirement. I tend to, if it's a bad deal for you, don't take the deal.
Well, to answer your question, I wasn't here per se suggesting we should make this a legislative solution.
Right.
I'm really talking more about a policy kind of solution. And yes, I realize we can walk away, but the history of I think many of the firms that serve the state is one of collaboration and working with the agency. So we're here as a conversation to explain we have some problems that are that come from this.
Fair enough. You want us to try to start a conversation with the government agencies rather than to be heavy-handed with them. That's fair enough. That helps me a great deal. Thank you.
And recognize Representative Wilkerson.
Thank you, Mr. Chairman. So just to clarify, so it is public agencies that you guys are really concerned about, not legislating from the private side of it, more so. Or not even legislating, the conversation, I guess I should say.
The conversation, I think, well, given where we're sitting, it would be with respect to state agencies, I think. But the concerns, we have our concerns very much with the private sector as well. There may be the worst transgressors, but we don't believe, because of what Mr. Trigg said, is that since this copyright is federal legislation, that the state of Georgia is likely to be able to pass some law that could be imposed on all businesses signing contracts in Georgia with architects that would be binding. It seems like that would be against federal. So I don't know if I'm answering you.
Yeah, you are. And I guess the follow-up question is, we represent 55,000 folks or whatever it is. Now, besides the architects, what would be the benefit to the people in our area to not have the, I guess, state agencies be heavy-handed or whatever we want to say? I mean, what's the benefit to the general public good of not transferring these rights?
I think I can touch on that answer. First of all, to go back, though it is a private sector and public sector issue, it's an issue. It's a concern that's shared not just by the architectural community, but also by the engineering community. And I think that that one point to make is that recognizing that we want to encourage innovation in the state, and we don't want people who just have to be who just want to settle for a project to take on state of Georgia projects, maybe because they need work. If we want to encourage innovative design and engineering by architects and engineers, civil engineers, landscape architects, all of the folks involved in the building industry, we think it would be a good practice to address this in some way.
So I guess the last piece of that then, I guess, is that, if we did say, if you don't want to transfer the rights, then don't take the business, there's a potential, I guess, is there a potential risk that you won't get the best because they'll go elsewhere to take those services? So the state will not be getting the best. They'll be taking the people that potentially could just need the business more so. Is that a risk?
Do you want to? Let me see if I can answer this question. Maybe play it out a little bit. So these.
And again, I'm being sensitive to time.
Yeah.
Sure.
We've been working on about a 15-minute slip. We're looking at 20 minutes time slip.
So there's a certain limited number of architects practicing in the state of Georgia. So imagine that all of them have put their wisdom, their knowledge of decades of work into these databases on details and how to build a building. And they transfer that entire amount of knowledge to client A. And maybe they can't use those details when the next project comes along that requires those elements. They've got to reinvent them. What you're going to end up with eventually is a limited number of firms that can do that work at a quality level, or the same firms that are having to reinvent it, and there becomes a really significant health, safety, and welfare concern that whether you're a public or private client, you're not getting the highest quality of work because someone else has already bought all of the good pieces and tied them up in their project and said you can't use them unless we get permission. And I think that is a significant public policy issue, both from a standpoint of savings to citizens as well as getting the best quality work that protects their health, safety, and welfare.
And is there truly a public interest in having exclusive copyright for those details, or is it really having full access to use what's been given to you by a design team for your own purposes? Is preventing them from ever reusing it really a public interest? That I think is the issue. So I do have a couple of questions. We're going to go rapid fire here. Representative Oliver.
Thank you, Mr. Chairman. I guess I have two quick comments. One is, as a representative, I do want our state government to utilize the best architects possible, so I would be interested in learning a little more from the state, how they're going about selecting great architectural work. And then Chairman Martin, just one quick thing, and I'm just kind of thinking out loud on this, but if all the architects got together and refused to work with Georgia, it might be an anti-competitive practice that might be actionable. So I don't know, but from our standpoint, I would be interested in making sure our state governments do get the best work they can, seeing how we could do that.
Oh, thank you, Mr. Chair. So my question real quick is, so in the process of working with state contracts, is it that the process of how they go about, bidding and awarding work does not lend itself to sit down and have a negotiation? It's sort of like here's our requirements and parameters, take it or leave it?
This Contracts Alliance Committee that I mentioned is a group that has some agencies participated in it to have ongoing discussions about refinements, not just of design contracts, construction contracts, other kinds of contracts. The selection process is a wholly different animal. It's conducted under a system typically referred to as quality-based selection, where it's a selection based on the perceived quality of the firm and their appropriateness for the project, and irrespective of money is not discussed until after the best number one choice is made, and then you try and negotiate a contract with that firm. So it's a different process, totally separated, I would say. This is really just more about refining the way the state's entities contract for professional services, and is this a refinement that can be, that most state agencies could buy into, a different approach of not transferring the intellectual property per se, but instead taking a perpetual license to meet their needs. And if Agency 1 wanted to be able to, let's take an example, if Agency 1 was GDOT and they wanted me to design a welcome center for Interstate, and they told me up front they want to build this 5 times just like this, then fine. We have a discussion and we arrange for a contract that's based on that and the risk attendant to it. And whereas if Agency 2 is building a unique science building and doesn't anticipate rebuilding it, then they don't need that additional license, if you will. So.
Well, I would like to look at how we go about that too, because I know that sometimes the way we go about bidding stuff does not lend itself to a back and forth collaborative process where there's give and take. It's we spec it out and we bid it out, and it's kind of a parade. You go through a parade and there's a lot of ticker tape and everything's kind of measured the same, and you don't really take into consideration those unique qualities and benefits that an organization has, because it's you've got to bid to our specs, and it's a spec proposal rather than who's really, I don't see how they would sort out and determine who is the best and most innovative person for the work in the process that we typically go through in government for bidding out work. So I would be interested, as he said, in looking at more about how we're doing that. So thank you.
Thank you. Gentlemen, thank you for your presentation. I've got one more speaker here, John Hinton. Chair recognizes Mr. Hinton from Baker Donaldson. Again, I appreciate committee's time. It's 11:45. We're going to have a hard stop at 12 noon. We were hoping to stop at 11:45, but having said that, please.
Well, good morning again. My name is John Hinton. I'm with the law firm of Baker Donaldson. I do realize that we are close to the end of the allotted time, so I'm just going to go very high level with my comments, and then if people need more details, feel free to ask questions, but I want to be respectful of y'all's time. Again, I'm an attorney with the law firm of Baker Donaldson. I have been practicing primarily in the areas of construction law, both in the drafting of contracts and also in the unfortunate litigation that arises with projects down the road for more than 20 years. I also serve as a member of the board of directors for the South Face Energy Institute here in Atlanta, which is a nonprofit focused on sustainability for the construction industry. I was asked to give some comments this morning on kind of the owner perspective on these issues. Let me say that in my work in construction law, while I have represented some owners in the past in my work, a lot of my work is for design professionals. So a lot of what I bring to you is the presentations and the arguments that have been given to me as we negotiate these contracts and what comes out as being important to the owners. But hopefully, as any good lawyer, you can argue both sides of the case, and that's what I hope to do here just for a few minutes this morning. And again, my comments are focused on the private sector, but I think they carry over to the public sector, which seems to be of primary concern to the committee. So I think there is going to be some overlap that will be helpful for you. But I think that if you look from the owner's perspective, the issues that come up that drive them to ask for the protections that they're asking for in the contracts really fall into three buckets: cost, control, and continuity. And I just want to highlight those real quick. On the cost aspect, building any project is expensive. And having the design professionals who provide their services, which are important and necessary and integral part, are expensive as well. And from the owner's perspective, just as Sal was talking about how they work on a project and they build experience that they want to bring to bear on the next project, owners would like to do that as well. And they look at it from the perspective and say, I have spent a considerable amount of money to have this design prepared. I've paid for it. I would like the ability to use it on future projects. And by doing that, to help drive down the cost of the next project that I work on. With any developer in the private sector or in the public sector, they're thinking beyond the next building. So that cost element is important to them. And if they have control of the design, then they're able to control the cost going forward with reusing it and not having to start from scratch. So that's number one. The second is the idea of control. You've paid the money, you've gotten the design that you like, and you'd really like to not see that design show up on the street corner across the street from where you are or in the general area. So you would like to be able to have control of that design so that you do not have down the road someone else, a competitor, putting that same design out there and coming up with something substantially similar and marketing it to tenants, whether they be commercial or residential. So they want to have that control. The third aspect is the idea of continuity. These designs are not utilitarian, and they do desire to use these designs on future projects. so that they can have that same look and feel across their footprint, whatever that footprint might be. In the private sector, it may be an apartment complex that wants to have that similar look and feel across the city or across the country. With a school, they may want to have the similar look and feel with the buildings across the campus. And they want to be able to ensure that they have the ability to bring those designs to bear on future projects. The limited license can raise some issues with that, because when they go to the next project, they've got to deal with a couple things. First, is the design professional willing and available to work on the project, the one that has control of the design? And second of all, will the design professional use those rights as leverage in the negotiation to be able to do the next project? And as you can imagine, from the owner's perspective, they do not want to be in a situation where they're beholden to a particular design professional in order to build their future projects. So it's a protection of their position there. So the idea behind having ownership of the copyrights is to address those issues in two particular ways. One is you have some contractual risk any time that you put together a contract. And the lawyers come together and they negotiate and they try as best as we can, just as we do with legislation, to put it into language that'll be easy to use and easy to understand, and will put clear lines of demarcation as to who has what ownership rights, who has what rights going forward. As best as lawyers can do and as parties can do, those lines sometimes are not clear down the road. 5 years down the road, 10 years down the road. And so by having all of the rights transferred to the owner, we get out of the gray area where it's clear that they are going to be able to assert the rights that they want to be able to assert down the road. The other issue is what I would just call business risk. Construction projects are fraught with opportunities for conflict. If you look at any building that's out there, sometimes you look and you marvel, how did this all come together with all the parties that had to come together to make this work? And any set of delays that happen in the construction project because of disputes or time, which is money for the owner, whether it's in the public or private sector. And so maintaining that control allows the owner to contain control over the costs, which can be very important on any construction project, because the money that you're going to make out of it comes down the road. So the delays in the project lead to the delays in getting that money. So again, that's a little rushed, but that gives you the overview of what the owners are looking at, what concerns them, and why they're seeking the rights that they are. And I'm happy to answer any questions or anything that I may have blown over a little too quickly in trying to get you out on time.
What questions are there? I've got a question for you. Where have you seen in your practice, or have there been cases where there's been an owner who was actually truly committed to getting every little detail tied up in copyright ownership versus, I don't want another apartment building looking like mine. There's this really cool entry piece that I like. I want to kind of copyright that. Have you seen examples of owners, though, that have gone in intentionally and captured these fine details? Because I certainly see these details and assemblies that are put together that really are the building blocks of buildings. I think we can all clearly see that being a real issue if that's assigned away from a design professional and they lose access to that. Are there owners that really look for that kind of exclusive control, or do you think at the end of the day they may use the term copyright, but what they're really trying to do is retain access for a future design? Where have you seen that line drawn in terms of?
Great question. Let me hit on 2 points on that. One is that in my experience, most of the owners will allow for some sort of carve out from the rights to protect prior works, what you bring to bear on the project. That being said, the owners do, when you see that initial draft of the contract, they can go as far as what you're describing, Mr. Chairman. And I think that a lot of what drives that is this idea of the gray area in the contract. And we're looking at point A, and 6 months down the road, a year down the road, 5 years down the road, what exactly is it that I want to be able to use? I'm not sure, it hasn't even been developed yet. And so by taking all of the rights, or as many as they can, the owners are trying to eliminate the gray and have it all in their favor. So that to me is the big driver. The purpose is to eliminate the gray, but at least in the private sector, I have not seen owners that have been unwilling to give at least a little, maybe not to the complete satisfaction of what the design professionals like. Now, in the public sector, my experience has been, here's the contract, and it is what it is. And a lot of times those contracts are put together. This document pulled from here and this document pulled from here, and it looks a little bit, respectfully, like Frankenstein's monster, and can create some real issues. I'm not sure that they are as thought through as well on that private end, and that there are some opportunities to do some balancing with the contracts in the public sector that could be a benefit to everybody.
Is it fair to say many markets, Atlanta's a pretty healthy market with respect to design professional availability? I asked the question, I know we certainly are concerned about rural health care. There's not doctors and medical professionals in every rural part of the state. So there's not doctors competing to serve people, right? Is it fair to say that across Georgia, if there's a $10 million building at Georgia Southern, there's plenty of design professionals that are qualified lining up to pursue that job? Is that fair to say?
Not necessarily. I mean, there are a number of them in a state this size, but you do run into the issue of whether they're being incentivized to be able to do the innovation that is of benefit to the public, not just from the look and feel, but also from life safety as well. So you want those design professionals to be incentivized to do the development that will be of benefit to the public, whether it be a private building or whether it be a public building.
And I simply asked the question because
Yes.
it seems to me that there's plenty of design professionals that are lining up. So there would seem to be in our process, there may be a most qualified design professional. If a contract term is put in front of a design professional that says, "Hey, here's our contract. You can walk away from this opportunity if you want to, but there's 10 qualified people behind you who will step up, and somebody in that stack's going to sign our contract." It seems to be there's a circumstance today, just from what I can see, that there are some. If in fact it is a questionable business practice on the government side to demand full copyright. There seems to be a circumstance where if that were asked, somebody in that stack of design professionals is going to raise their hand and say, "You know what, I want this work bad enough. I'm willing to sign that contract and to get the work." Versus, and that's a concern of mine as I listen to this, that are there perverse incentives that incentivize design professionals to sign something away they shouldn't because there's somebody who'll step right over their chest and take the job, and if they won't take it, the next one will.
Well, there is, and that hits in two ways, both the innovation piece, but also that you have people potentially that are doing the work that really aren't qualified to do it. I mean, they're qualified in the sense that they can convince the owner to give them the work, and they can sign the contract, but do they really have the expertise that they need to be able to do the sophisticated level of work that is necessary, which again, in the construction industry, we're not just talking about whether the building is beautiful like we would, whether the photograph is beautiful or the commissioned work of art is beautiful. There's a real life safety issue here that has to be considered as well. So we want to incentivize the best and the brightest in a regulated profession to be the ones that are working on the best and most important projects.
Any other questions? Hearing none, before we start shuffling, I want to kind of draw this to a conclusion as I see it, and I'll take one last line of questions or comments from members of the committee if they should choose. I've heard perhaps there's two categories of issues. There's this pursuant to private contract, and there's this pursuant to government contract. You know, we as a General Assembly have not just direct responsibility and oversight over our executive branch as a state, but local governments certainly fall within the purview of the General Assembly. So it's certainly an area of interest for us. I have no predetermined outcome to that. That's why it was interesting to hear this kind of this back and forth, and I appreciate your presentation today, kind of on the other side, so we can. I think sometimes until you see clash on the issue, you're not really able to understand where the issues lie. But from the perspective of the state, I don't know exactly what we're doing. I don't know exactly what every local government's doing. But to AIA, this issue was brought to us during the session, and I wanted to early here in the summer tee this up. So if there does need to be a working group established to look at what contract terms are being put in place at the state level, county, city level, or even on the private sector side. I don't know if AIA has standard contracts that evolve over time. I don't know if there needs to be kind of a professional development discussion around this. I would certainly challenge you all as an association to your emerging architects that maybe don't understand these issues as well to make sure folks understand what this means, because copyright's a really big thing. It's pretty absolute when it's signed away, and I think we don't want emerging architects in Georgia to be in the place of John Fogerty in the 1960s as an emerging artist. So I share that. Appreciate members of the committee kind of walking through this. There may be some further discussion around this over the interim, but I do want to tee this issue up and appreciate everybody being with us today.
Thank you very much.
We're going to stand adjourned. We've got a bus waiting for us downstairs to go to the Google Data Center. Chris, any instructions for us as we go?